The courtroom grew hushed as former Florida Attorney General Pam Bondi stepped toward the podium in Judge Paul Engelmayer's Manhattan courtroom. The bright overhead lights etched deep shadows across her face, revealing a resolve honed through years of legal battles rather than public applause. This wasn't a role she had chosen, yet it might define her legacy. At 56, Pam had carved out a formidable reputation as a constitutional lawyer, her tenure as Florida's first female attorney general equipping her with a keen eye for detail. Today, however, she faced an intimidating challenge against entrenched legal norms and a judge whose skepticism loomed large. Ms. Bondi, do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? So help you God? The clerk inquired, her voice steady in the stillness. I do, Pam responded firmly, adjusting her posture with quiet confidence. She cast a brief glance at the crowded gallery, filled with seasoned legal journalists, attorneys, and privacy advocates, before focusing ahead. Judge Engelmayer, a 63-year-old jurist with a sterling reputation in the Southern District of New York, reclined in his seat. Known for his piercing questions and meticulous rulings, he had presided over countless cases, his courtroom a bastion of his unshakable authority. As Pam rose, Engelmayer leaned toward his clerk, his voice low but audible through the microphones. Let's see her next move. His faint, dismissive laugh sent a ripple of discomfort through the room, captured on camera and quickly spreading online. A moment that would soon haunt his distinguished career. This was the second day of a pivotal hearing, challenging a newly imposed federal regulation on interstate medical data sharing. The government defended it as crucial for national health security, while Pam, leading the challengers, argued it breached Fourth Amendment rights and overstepped congressional limits. The stakes were immense, affecting rural healthcare access, emergency services for travelers, and the privacy of millions. Healthcare giants had poured millions into compliance, yet privacy advocates decried the risk of excessive government intrusion. For Engelmayer, the case offered a chance to influence future law at the crossroads of technology and privacy, his decision potentially echoing for decades. For Pam, it was both a professional duty and a personal mission. Viewing the regulation as a threat to individual freedoms and aware of Engelmayer's prior dismissal of her arguments in a ruling, Ms. Bondi raises intriguing hypotheticals, but they must meet legal reality. The Justice Department's attorneys sat with assured smiles, exchanging subtle nods as Pam prepared her final stand. They anticipated Engelmayer would uphold the regulation, closing the case. Unbeknownst to them, and certainly to the judge, Pam had spent the past 72 hours tracing a trail of evidence that would upend the proceedings. Standing before Engelmayer's lingering smirk, she knew the next 17 minutes could validate her exhaustive efforts or seal his low opinion of her case. Either way, she was determined to command his respect. Your Honor, she began, her tone steady and assured, before you issue your ruling, I wish to address 3 key developments since our last session. Engelmayer tilted back slightly, his voice tinged with sarcasm. Ms. Bondi, I've thoroughly reviewed your additional filing. I'm unsure what new insights you think have surfaced, but go ahead. His emphasis on new prompted a few smirks from the government's side, which he ignored. Thank you, Your Honor, Pam replied, unfazed. She withdrew a document from her briefcase and handed it to the clerk. My first point challenges the department's claim of extensive consultation with healthcare and privacy experts. This is a full record of stakeholder meetings, secured yesterday via a Freedom of Information Act request. Engelmayer took it with a hint of irritation. Ms. Bondi, the record closed months ago. Procedural challenges are untimely. I acknowledge that, Your Honor, she said, but this wasn't available during the record's compilation despite our requests. Please turn to page 3. Engelmayer skimmed it, his face unchanged. I see meetings with healthcare and privacy groups. This seems to back the government's stance. Notice, Your Honor, Pam pressed, these occurred after the regulations were set. They were briefings on implementation, not input. The government labeled them collaborative, but this proves no stakeholder feedback shaped the rules beforehand. A quiet shift stirred the room. Attorneys rustled through papers, and Engelmayer's clerk murmured to him, drawing his closer scrutiny. Even if accurate, Engelmayer said after a beat, this might warrant a remand for proper procedure, not the outright rejection you're seeking. That holds true in typical cases, Pam countered, producing another file. But my second point explains why this isn't typical. This internal memo addresses constitutional concerns during drafting, admitting the regulations likely exceed congressional authority. The government's lead counsel, Michael Hayes, rose swiftly. Your Honor, we're unaware of this document. We need to verify its authenticity and object to its admission without foundation. Engelmayer's amusement faded, replaced by a professional frown. Where did you obtain it, Ms. Bondi? A whistleblower from the department, Your Honor. I can submit an affidavit on custody and use metadata and signatures to confirm its legitimacy. The strongest proof lies in my third exhibit. With deliberate care, she presented a series of email exchanges. These show the department knew the regulations overreached, but proceeded, citing their chief counsel. Courts will likely defer to our expertise despite ambiguous authority. The room fell into complete silence. Engelmayer examined the emails, his brow creasing with concern. Hayes's team huddled, papers shuffling. Your Honor, Hayes finally said, these may be protected deliberative processes. We move to exclude them in sanctioned counsel. Engelmayer nodded thoughtfully. The deliberative privilege isn't absolute, Mr. Hayes, especially with allegations of misconduct. But authenticity is my priority. Ms. Bondi, can you establish origin without exposing your source? Yes, Your Honor. Metadata traces the documents to department systems and identifies authors. I can also offer sworn statements from former officials to authenticate them without revealing the whistleblower. Very well, Engelmayer said. The government has 48 hours to verify or contest authenticity. If genuine, I expect a substantive response, not just procedural objections. Hayes's expression tightened. Your Honor, these discussions are standard agency practice to ensure robust regulation. I'm well aware of the privilege, Mr. Hayes, Engelmayer replied curtly. But Ms. Bondi alleges a deliberate overstep, using deference as a shield. That raises serious separation of powers issues. The case had morphed from a routine hearing into a potential landmark ruling on agency limits and judicial oversight. Engelmayer, who had chuckled at Pam moments ago, now leaned forward, his focus intense, all mockery gone. The court will recess for 30 minutes, he declared. Ms. Bondi, Mr. Hayes, join me in chambers immediately. As he left, the courtroom buzzed with whispered debates. Reporters dashed to file stories, and clerks huddled, dissecting the turn of events. In chambers, the discussion continued privately. 3 witnesses later recounted Engelmayer addressing the tension. Ms. Bondi, I apologize. My initial reaction was unprofessional. However, I'm troubled by how you acquired these documents. I appreciate that, Your Honor, Pam said. The whistleblower followed federal protocols, internal channels, then the Inspector General, reaching my client only when those failed. Hayes cut in, Judge, these are protected deliberative materials. We demand exclusion and sanctions. Engelmayer paused. The privilege has limits, especially with potential misconduct. Authenticity matters most. Ms. Bondi? I can prove origin with metadata and declarations from former officials, safeguarding the source's identity. Engelmayer nodded. The government has 48 hours to verify. If authentic, address the content, not just procedure. Returning to court, Engelmayer announced a delay in his ruling, ordering further briefing and maintaining the regulation's stay. The shift was monumental. A case nearing dismissal now faced deep scrutiny, putting the government on edge. Legal watchers were awestruck. Joyce Vance, a former U.S. attorney, tweeted, "Witnessed Pam Bondi deliver a legal knockout in SDNY from judicial smirk to shock in 15 minutes." Pam left the courthouse composed, facing a swarm of reporters. Asked about Engelmayer's early disdain, she said, "Every lawyer faces doubt. The answer is preparation and focus on the law. Judge Engelmayer engaged seriously. That's enough." Beneath her diplomacy lay the reality. A judge who scoffed at her had been compelled to rethink. 2 days later, the government confirmed the documents' authenticity, but argued they were misconstrued, heightening their impact. A week later, the Washington Post revealed senior officials had urged broad drafting, quoting an email, "Chevron allows us room. Take it." The ripple effect spread. Law schools added the hearing to syllabi, and analyses like the Bondi breakthrough debated agency deference. 2 months later, Engelmayer issued an 87-page ruling, declaring that intentional overreach relying on deference demanded closer scrutiny. When evidence shows an agency exceeds its mandate, banking on judicial leniency, that foundation fails, he wrote. The decision struck down key regulation parts and remanded others, hailed as a landmark reshaping court agency dynamics. For Engelmayer, it was a humbling lesson. His confidence had blinded him to Maria's case, a misjudgment he addressed at Yale Law School 3 months later. "The greatest risk is assuming we know the outcome before hearing the case," he told students. "I was reminded by an advocate I underestimated, and it improved my judging." For Pam, it was a career pinnacle, earning the American Bar Association's Advocacy Award and boosting her firm's appeal, especially among women lawyers. In a Florida Bar Journal interview, Pam emphasized principles over personal triumph. This wasn't about shaming anyone. It was about ensuring agencies respect congressional limits. Judge Engelmayer's decision will echo for years. The government dropped its appeal after a new administration revised the rules, balancing security and privacy needs. 6 months later, the Supreme Court took up a related case, citing Engelmayer's ruling and Pam's hearing as a constitutional turning point. What began with a judge's laugh evolved into a profound reevaluation of administrative law's core tenets. It rested on one advocate's refusal to be overlooked and her meticulous readiness to seize the day. For young lawyers, the takeaway was clear. Legal mastery combines knowledge with the courage to challenge authority, even when dismissed.